Hi, thank you for joining our webinar. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We are a national construction document service. Today's webinar is conducted by the wonderful Jessica Murphy, a Massachusetts construction lien law expert. Today's webinar topic is a contractors, subcontractors, and suppliers step-by-step guide to getting paid. So without further ado, I would like to introduce the fabulous Jessica Murphy.
Oh, thank you for that wonderful introduction. So I'll just start out quick with a little introduction about me. I'm in construction law, the daughter of a contractor, and I've been doing this for almost 20 years now. I'm currently at the firm of Tarlow, Hart Rodgers in Boston and cover all of Massachusetts. This is a Massachusetts specific webinar, and I know that SunRay has attorneys in all different states, so if you have issues come up in other states, don't hesitate to reach out to SunRay. They can connect you with mechanics lien and other attorneys in the area who can assist you in any other state. So without further ado, let me get to our first slide. Here is just a quick update on how to ask questions here. If you have a question, just use the webinar chat box on the right. I will answer all the questions at the end, and I'm happy to answer any sort of specific questions you have, but please don't include company names in the questions. As this is being recorded, this also gives you, by recording it, the option to go back and check out anything that you need. Also, as you'll know at the end, feel free to, at any time, send me an email or reach out to me directly if you have questions on any of the material. We're going to keep it to a quick 20 minutes so that we can kind of give you maybe a lunch and learn and get you on your way. So it will be a little bit quick. If anything comes up where you have a question because I ran over something too quickly, don't hesitate to drop that in the chat box as well so I can see. But without further ado, what we're talking about today is here's kind of generally what we'll go through. Your contract, you want to make sure that here's the minimum that your contract should have to best protect you and your company. Talk a little bit about lien rights in Massachusetts, bond rights and how to secure them, lien and bond rule exceptions, things you need to know that are going to make a difference. Here's the big traps you can avoid in mechanics lien law in Massachusetts. Here's a quick, talk about how to get paid and give that release. Make sure that as you get this resolved, you're really getting it done and done correctly. And then Jessie will come back in with a couple of bits about SunRay's resources and what they can do for you. So first thing at the outset, check your contract. I always suggest that my clients check their contracts at least every 2 to 3 years. You can do it on an annual basis. The great news is you can make it out to be, here's our annual or here's our periodic review of our contract. If your contract isn't great, update it. Ask your clients to re-sign it. You can always, I like to tell people, you can use me as the bad guy. Hey, our attorneys say that they want us to be using this form going forward and everybody has to re-sign. So that's a great way to just make sure that you've got good terms and conditions and you've got everybody on those same terms and conditions. So here's what you really, at a minimum, want to have to best protect yourself and your company. Make sure that your contract has proper identification of the parties and signatures. Signatures are going to be really important when it comes to mechanics lien law if you need to rely on a credit app or a purchase order. So proper identification of the parties means know if they are an incorporated entity, if they are an LLC, know if they're a DBA. I would also suggest that you take the time to look at the resources available online, such as the Secretary of State's website, to check and make sure, because a lot of times people will not put Inc., LLC, et cetera, at the end. You may not be quite so sure. Maybe you have a relationship with somebody that's been going for years. So people aren't going to be as concerned about making sure that the contracts are properly filled out because, hey, you guys know me, is kind of what I hear. Use the Secretary of State's website. You can look up the corporate in the corporate directory and find, you can either look by the individual's name or you can look by the company name, find their full legal name and make sure that's on there. Make sure the right people are signing it too. detailed scope of what it is that you're supposed to do, where are you supposed to provide, how many things, what are the terms. Those should be really spelled out so that we know what everybody's obligations are under the contract. And the other most important thing, if we're going to cut this down to a couple of bullet points, are going to be making sure that the payment terms are in there. Are you net 10? Are you net 30? When does interest accrue? If interest is not stated in Massachusetts, it accrues at 12% a year. That's the interest rate you could get if you had to go to court. Otherwise, put your own interest rate in there. You can go as high as 22% without being usurious. So you can charge that. It's very typical to see 18%, which is always nicer to put at 1.5% a month. You can add late fees as well. And then for attorney's fees in Massachusetts, you must have those expressly stated in the contract that you can recover them. Otherwise, they are not recoverable. So always the best minimum 3 things I'd like to see in your contracts. Lien and bond rights, again, these are Massachusetts focused. In order to enforce a lien, you must have a contract. It must be signed by the party that you're working with. If you are a supplier and a subcontractor is coming to you, the subcontractor must have a signed contract. We can use a credit app. It's much preferable to have a purchase order, a signed purchase order for each particular job they're doing. Know the parties in the job so you know where the party that you're contracting with is in the scope of things. Are you a 3rd or 4th tier subcontractor or supplier, or are you supplying directly to the GC or directly to the owner? The only difference in mechanics lien law is that the further you go down the chain, you may need to file a notice of identification to preserve the full amount of your mechanics lien. So those things make a difference. So it really helps to know where you are. Timing is key in mechanics liens. You need to make sure that you are recording and filing suit along the proper time frame. Generally, that's going to be 90 days from the last date that anybody does work on the project. You have to record your first document. Then you have 120 days. So typically, if you wait till the last minute, you've got another 30 days to do the statement of account, which is the second document, and then another 90 days after the statement of account in which to file your complaint. So you do start with recording with the registry. That is nice because it means you don't have to first go to court. The first filings are done outside of court, which is recording those notice of contract and statement of account documents. You continue to perfect by meeting all the deadlines, and ultimately that becomes filing in court with a lawsuit. And when you win, the key here about mechanics liens, and the reason they have such great leverage, is that to win a mechanics lien case gives you a right to sell the property to satisfy your mechanics lien. That's hugely powerful, especially because as a supplier or a subcontractor, you don't have any direct relationship with the owner. So this is a very powerful way to get paid. In the almost 20 years I've been practicing, I've only had 2 mechanics lien cases go to a judgment that has had an order to sell the property. And that's essentially because people know how powerful these things are. Owners will, if there is a balance due and there is an amount that they owe under the mechanics lien statute, they will pay it. So that's the good news. The exception you do want to be careful of is knowing when that it's your mechanics lien, no matter where you fall on the chain, is going to be limited to the amount due to the subcontractor above you at the time the owner has notice of your mechanics lien. So you want to obviously think about how money flows in the project. If you're down in the lower tier, you want to make sure that you get that mechanics lien on and at least start the process with a notice of contract early, because otherwise, as the money flows through the project, you may reach a point where the subcontractor above you has been paid in full and there's no money due on your lien. If they've been partially paid, then it will partially reduce the amount of your lien. Okay, traps for the unwary on mechanics lien. Your obligation is to provide, to prove that the materials that you provided or the services that you did were used in the property liened. So the best way to do that is to keep your, get signed delivery tickets. It's to make sure that you put the job name on the invoice. Make sure that you put the delivery address on the invoice. If you're delivering to a warehouse, it makes it much more difficult to know where those were actually used. If you have a purchase order for a particular job, you have delivery tickets. All of those things together are going to help show where the materials were used and to help get you paid. Don't wait until the last minute. It does take some time, depending on some of the property addresses, to check and make sure that you do have the correct property address so you can record it properly. It takes a little bit of time to actually do the physical recording, especially if it's registered land. So keep an eye on these things. What I like to tell people is set a tickler for maybe 45 or 60 days from the end of the work, your work, because perhaps the job has actually gone on longer. But if you know when you completed your work, then at least use that as a benchmark, because that's what you can prove. About 45 or 60 days, check in to see, do you think you're going to need a mechanics lien, so you can get those things timely done. Getting paid by wire close to the deadline is a very difficult issue, because paying by wire is actually the best way to do it. But if you take a check and the lien deadline is tomorrow and you've asked counsel to hold off, or you've asked SunRay to hold off on recording, you're going to be in a position where maybe that check is not good. Maybe they stop payment on the check. Maybe there's no more money left in the account. So what you want to do is make sure that if you're getting paid close to a mechanics lien deadline, you either let them know, hey, you can give me a wire, which is immediately available funds, or if you don't do that and I have to wait for your check to clear, I'm going to go ahead and file the mechanics lien, and then you're going to have to pay to take it off later, because I don't want to risk that there's a problem with payment and my mechanics liens expire. There is no way for the court to go back and say, oh, well, you wanted to file a mechanics lien, but they bounced the check. Sure, we'll give you extra time. Those lien deadlines are absolute. Bond rights in Massachusetts. So there are two types of bonds. There's a payment bond and a performance bond. This will actually be right in the name on the top middle in bold, usually on the bond itself. You're not concerned with a performance bond. That is to benefit the owner, and it's to make sure that if performance stops for some reason, the owner can use the funds available under a performance bond to finish the job. What subcontractors and suppliers care about, and general contractors too, although they're typically the ones posting it, they care about the payment bond. So the payment bond is there if you don't get paid and you are a subcontractor, then, and if you're a subcontractor who has a relationship with the bond principal. And what that means is typically it's going to be the owner requiring the general contractor to post these bonds. When they post the bond, if you are the subcontractor or the supplier who works directly with the GC, then that's going to be the bond principal. And in that case, you have 1 year to file suit. If you have an issue 1 year from the date of when payment was due, you can just simply file suit. I always recommend giving notice under a bond because the bonding companies will largely pay these if they're due. If you do not have a direct relationship with the bond principal, this is why it's so important to know where you are in the chain, then you're going to have to give notice in 65 days from when you have not been paid that you haven't been paid. You give that notice to the bonding company and the bond principal, and then you still have a year to file suit, but you're required to give that additional notice if you are if you do not have a contractual relationship with the person who posted the bond. If you can, obviously get a copy of the bond, find out the bond number, do these things early in the process because that's going to be a great way to make sure that later on, if you need it, you have it handy. The good news in Massachusetts is that bonds are required on public projects. You cannot put a mechanics lien on a public project. So the good news is that you have an option. Either you're going to have mechanics lien rights on private property, or you're going to be doing work on public property, in which case you have no mechanics lien rights, but you do have bond rights. A project owner can also require somebody posts a private bond on a regular construction job. It happens for a lot of the larger jobs, but that's not always necessary. If that's the case, and it's a private job that has a bond on it, you do have mechanics lien rights. You also have bond rights, and the bond timing is going to be determined by the language of the bond itself. So again, a reminder how important it is to get a copy of that bond. Here's how to get paid the right way. I know, we all thought it was just as easy as taking a check. But make sure that getting paid really resolves it for you. So again, going back to law firms today, with all the issues going on, are no longer allowing certified funds to be treated as immediately available and are still waiting for those to clear. So we suggest wire. A lot of companies will still accept a certified check. But again, make sure you get those immediately available funds if you're going to give up your rights at that time. Review the scope of a release or a lien waiver that you're being asked to sign. I will tell you that probably 100% of the lien waivers that my clients get are overly broad and include a general waiver, when in fact, by law, they can be limited to just being a lien waiver, for which means you're giving up your right to lien for the amount of money that you've been paid. And then the last part is, if you can, always good to make sure that any release that is given is mutual. So if you're giving up your rights to sue them because you've been paid, what you really want to do is know that the job is done and over. So you want to make sure that all the claims are going to be extinguished. Again, that's how you get that mutual release. All right, and in 17 minutes, I have gone through a broad overview of how to get paid on Massachusetts construction projects. Are there anybody who has any questions? I don't see anything that's come up in the chat box yet.
Well, thank you so much, Jessica, for that presentation. You did cram it packed full of little nuggets of information for us to be able to use. So thank you so much. I actually do see a question that had come through on my screen. It says, can attorney's fees and filing fees be included in the lien amount?
Great question. They cannot be included in a lien amount unless you are the general contractor and your contract with the owner allows you to charge those amounts. Otherwise, what would happen is you would file the mechanics lien for the base amount that you're owed. It will have interest accrued on that as you proceed through litigation. But at the end of the day, when you file the litigation, your attorney should also include the party you contracted with, and if you have an attorney's fees provision in that contract, you can then seek the recovery of the attorney's fees from the party that you directly contracted with. But because the mechanics lien is against the owner of the property, who most of the time, if you're a subcontractor or supplier, you have no relationship with, the contractual right for you to get attorney's fees and extra interest and late fees isn't with the owner. So the law says you can only get the principal balance plus the court in going through and giving you a judgment will actually include interest as well. But great question.
Thank you so much for that. And then the other thing that that has been asked is, how long is my lien effective for?
So mechanics liens can be filed as early as when you have a signed contract. So you can start that process then. There are a lot of owners and a lot of general contractors who get nervous when they see mechanics liens started, also financing banks and things like that, so they like to have you clear them. But you can start them as early as when you sign a contract. They will continue once you initiate the first step and record the mechanics lien. As long as you follow up the process and you move to perfect it, your mechanics lien will continue to be effective. And again, remember that the deadlines for recording come on the end of the project. So let's say you have a 3-year project. If you're going to file a notice of contract, have a notice of contract recorded, call SunRay up. They're going to record a notice of contract for you perhaps at the beginning of the job. If the job goes for 3 years, then your mechanics lien stays effective for 3 years unless you waive or discharge it. And then it will stay effective until the project ends And then 90 days after that, if you have not done your notice of contract, which again is that first document, then there's no more lien rights. If you've recorded your notice of contract early, then at 120 days at the end of the project, when the statement of account deadline comes up, if you record the statement of account timely, then your mechanics lien will continue. But at that point, those first two recordings are based on deadlines that are based on the last date of work. Once you record the statement of account, you then have a solid 90 days. It's just 90 days, not based on anything else, but 90 days from the recording of the statement of account for you to file suit, and then as long as the litigation takes. So as long as you've done all those steps, your mechanics lien will be effective. Ultimately, once a judgment is rendered, and attorneys can expedite a litigation, they may want to drag it out to see if there's a resolution, but once you get a judgment, if there is a judgment for you in your favor on a mechanics lien case, that's when you get the order to sell, and then you can record that on the property and either proceed with the sale at that time or wait on the sale. But so as long as you're following those processes, it doesn't matter how long the job takes, it will continue to be effective.
All right, perfect. Thank you so much. Okay, now that is all the questions that were posed on here, but if anybody does think of a question that wasn't addressed, please feel free to reach out and we will be sure to answer any questions for you as soon as we can. Are you able to go to the next slide for me, please?
Absolutely.
Perfect. All right, who is ready to win a gift? We are testing your knowledge. If you can answer these questions correctly in our chat, we will go ahead and send you a little prize. Here are the questions. What documents will help you enforce a Massachusetts mechanics lien? And what is the most cost-effective way to secure your lien rights for anyone without a contract with a general contractor? For example, a second-tier supplier or a sub. So take a look at those questions. If you can answer in our chat, whatever you think that answer should be, if you've gotten it right, we will go ahead and get your contact information and send you out a little gift. Next slide, please. All right, so here are some of the SunRay resources to help you stay organized, know your deadlines, and secure your lien rights. Go ahead and scan that QR code to access these incredible resources. There's project information sheets, there's knowing your lien law rules by your state, there's deadline calculators, there's all sorts of things on there, so please go ahead and check that out. Next slide, please, if you don't mind. All right, please check out our new service. SunRay is offering SR receivables. We will handle your collections for you. We're here to help get you guys paid. So please go ahead and check that out if you want some information about our collections services. That would be wonderful. All right. The next webinar with Jessica is Don't Sign a Release Until It Passes This Checklist. That's Wednesday, March 13th at 12 p.m. Eastern Standard Time. So please go ahead and go to sunraynotice.com/education to sign up for free. We would love to be able to see you guys there. All right, now if you don't mind, take a moment to review us on Google, scan that QR code. It takes about a minute of your time. It just helps get this information out to other contractors like yourselves to be able to hear about us and get to know this information like the back of their hand as well. All right, and then with that is all we have for you guys today. Thank you so much for everybody that attended. We hope to see you at our next webinar. Thank you again, Jessica. You are incredible, and we hope you guys have a wonderful, wonderful sunny day. Thanks again.
Thanks, Jesse. Thanks, everybody who attended. And again, if you have any questions, don't hesitate to reach out to Jesse or myself. You've got our emails and phone numbers there, so grab a quick snapshot of that. And I hope everyone has a great day. Take care.
Thanks again. All right, bye-bye.